Hey everyone, welcome to my YouTube channel Brainacular Academy. This is lecture 1 of CA Intermediate, Corporate and Other Laws. We are starting with chapter 1, which is preliminary. Now before we start, let me tell you exactly what this lecture covers and what it does not, because knowing the roadmap matters. So today we'll do the foundation. We are covering the concept of a company, its characteristics, the doctrine of lifting the corporate veil, and the complete classification of companies, which includes holding, subsidiary, and associate. What we are not covering today is the section 2 definitions like KMP, managing director, officer in default, financial year, net worth, because those are heavy, exam critical definitions that deserve their own dedicated lecture. They are a part of lecture 2. With this, please do not skip lecture 2. Now, आज के लेक्चर में we'll set up the mental model. एक बार ये mental model clear हो जाएगा तो फिर definitions will automatically fall into place. So having said that, let's go. We'll start with section 1, which is the background. Now, India had the Companies Act 1956. It worked for its era, but as Indian business grew, as corporate frauds happened, and as investor protection became a national concern, it became clear that a new law was needed. One that was modern, accountability focused, and internationally comparable. The result was the Companies Act 2013, which was enacted in 2013 and operative from 1st April 2014. Three numbers now to know here, that there are 29 chapters, 470 sections, and 7 schedules. Now you won't study all 470 sections here. The syllabus picks specific chapters. We cover each one completely in this series. अब सीधा काम शुरू करते हैं. Now we'll go to section 2. What is a company? The statutory definition under section 2 subsection 20 states that company means a company incorporated under this act or under any previous company law. Simple. But this tells you only how a company comes into being, through incorporation. It doesn't tell you what a company is in legal terms. For that, we need to understand the single most important idea in all of company law. Why did the law create this concept? Before companies existed as we know them, if you wanted to run a large business, which is say a mine, a railway, a trading house, you needed capital from many people. But here was the problem. If each investor was personally liable for all debts of the business, rational people would never invest in any business they did not control themselves. Only the very brave or the very foolish would put money into someone else's venture. This killed economic growth. The law solved this by creating a legal fiction, a new person called the company, which is distinct from the people who own it. You invest in this person, not in the individual managers. The company owns the assets. The company owes the debts. You as an investor can only lose what you put in. ये एक brilliant legal invention था और इसी ने modern capitalism possible बनाया. This concept is called separate legal entity or the veil of incorporation. With this, we'll do the Salomon versus Salomon and Company Limited, the 1897 case. This is a landmark case, so we'll learn it cold. Aaron Salomon was a boot manufacturer, sole proprietor for years. He converted his business into a company which was known as Salomon and Company Limited. He held the majority shares. His wife and 5 children each held 1 share to satisfy the then legal minimum of 7 members. Now, the company ran into trouble. Creditors argue that this company is just Salomon in disguise. He is the company. He should pay personally. The House of Lords rejected this completely. The lordships held the company is at law a different person. Altogether, from the subscribers to the memorandum, the company is not in law the agent of the subscribers or trustee for them. Once incorporated, company alag, Salomon alag, full stop. Now this is a separate legal entity. The company has its own identity, independent of its shareholders, directors or promoters. It can own property, it can sue, it can be sued in its own name. अब students often पूछते हैं कि मैम, if company and shareholders are completely separate, does that mean shareholders can never be held liable for anything? Now this is a very good question. The separate legal entity protects passive investors from the company's general debts. A shareholder who simply holds shares cannot be asked to pay the company's creditors beyond their investment. But certain specific persons like KMPs and directors can be personally penalized for specific statutory violations. And if shareholders actively participate in fraud, the courts can lift the veil. The Salomon principle protects honest investors. It does not shelter active wrongdoers. That distinction is critical. From this, we'll move to section 3, which is characteristics of a company. So there are 6 characteristics. Each one flows logically from the concept of separate legal entity. So learn what each means, and more importantly, why the law designed in this way. First, we'll go with separate legal entity. The company is a legal person. It can own property, enter contracts, sue, and be sued independently of its members. Why? Because without this, the company cannot function as an independent economic actor. It cannot own a factory if the factory technically belongs to all shareholders individually. Second feature is limited liability. Members' liability is limited to unpaid share amount or guaranteed sum. Now why? Because this is the engine of capital formation. You remove personal risk, then more people invest, then more capital available for business, and which means economic growth. ये principle economies बनाता है. हम एक एग्जाम्पल लेते हैं कि आपने कंपनी में 10 रुपीज की फेस वैल्यू के शेयर्स लिए, उसमें से 7 पे कर दिए. अगर कंपनी डूब भी गई, आपकी मैक्सिमम लॉस रहेगा सिर्फ 3 रुपीज का. बाकी सब डेट्स कंपनी के नाम पर है, आपके घर पे नहीं आएंगे. So now we'll go to third feature, which is perpetual succession. And it says that the company never dies. Members, directors, they come and go. The company continues. Why was this made? Because a business should not die just because its owner does. Continuity allows long-term contracts, multi-year projects, generational wealth building. A classic exam की line है, members may come and go, but the companies goes on forever. Next it is common seal. Traditionally, the company's official signature or a physical stamp on formal documents. So ICI का एक trap है यहाँ पर कि common seal is mandatory for every company. This is wrong. Under the Companies Act 2013, which is as amended, common seal is optional. Remember, common seal is optional. A company may choose to have one or authorize officers to sign on its behalf. This is one of the most common wrong answers in CA intermediate exams. Now we'll talk about why it became optional. Because modern companies, they operate digitally. Physical seals are impractical. Authorized signatories, which might include 2 directors or 1 director plus CS, they serve the same purpose. Next feature is transferability of shares. Now shares can be transferred freely in a public company, subject to restrictions in a private company. Why? Because investment is only attractive if it's liquid. If you couldn't exit your investment, you would never enter. Transferability gives investors an exit route. Next feature is separation of ownership and management. Now shareholders own, directors and managers manage. These groups are often entirely different people. Why? Because professional management runs businesses better than passive investors always can. A retired engineer in Jaipur who bought Infosys shares should not have to attend board meetings. He invests, professionals run, and this way both of them benefit. अब यहाँ पर एक स्टूडेंट कंफ्यूजन का पॉइंट आता है. Students often ask, "Ma'am, you said common seal is now optional. Then how does the company sign contracts without a seal?" Under the Companies Act 2013, when a company does not use a common seal, documents require authentication, which are signed by 2 directors or 1 director and the company secretary. Their signatures on behalf of the company carry the same legal effect as the old common seal. So in this way, modern law recognizes authorized signatories. Next, we'll move to section 4, which is lifting the corporate veil. Now, we have established a separate legal entity is the foundational rule. But is it absolute? Can it be abused? Yes, it can. Some people set up companies not to run honest businesses, but to hide behind the corporate form while committing fraud, evading tax, or escaping liability. तो यहाँ पर लॉ का क्या रिस्पॉन्स है? It states that in specific defined circumstances, the court or the act itself will look through the corporate form and hold the real persons behind it accountable. This is called lifting of the corporate veil. I'll repeat once again. This is called lifting of the corporate veil. Now, why was this done? Because the corporate form was created to facilitate honest business, not to provide a shield for dishonesty. When misused, that shield is removed. It has few categories. First, we'll go to category A, which means statutory lifting. Act itself provides for it. So, what does it include? First is membership falls below minimum. This is depicted in section 3A. It states, if a public company's membership falls below 7 or private companies below 2 and the company continues business for more than 6 months after this, with the members' knowledge, every such member becomes jointly and severally personally liable for debts incurred during that period. Why was this done? Because the company structure was granted only on the condition that minimum governance standards are met. Breaching the minimum membership and hiding it is a form of misuse. Next is fraudulent trading. If company's business is carried on to defraud creditors, then every person knowingly party to the fraud is personally liable without any limit. Why? Because limited liability exists to protect genuine investors and not to enable fraud. Third is misrepresentation in prospectus. So here, directors who signed a prospectus with untrue statements are personally liable for investor losses. Next is judicial lifting. Here, the courts lift it. So the circumstances are as under. First is company used as a sham. So where corporate form misused purely to evade obligations or commit fraud. Second is enemy character. जैसे Daimler Company Limited versus Continental Tire and Rubber Company Limited during World War I. The company incorporated in England but controlled by German nationals. Court lifted the veil because it had an enemy character. Third is tax evasion. If a company is formed purely to avoid tax, courts look through it. अब यहाँ पर एक और confusion का point आता है. Students often say, "Ma'am, if courts can lift the veil whenever it seems unfair, doesn't that destroy the entire Salomon principle?" So this is exactly the right concern. And the answer is courts do not lift the veil merely because it seems unfair. Lifting is an exception applied in specific established categories, which are fraud, enemy character, tax evasion, and statutory provisions. Salomon's principle remains the rule. Lifting of veil is the exception. Courts have consistently refused to extend veil lifting simply because a creditor feels aggrieved. The Salomon principle is strong and well protected in Indian law. Next, we'll move to section 5, which is classification of companies. अब बारी आती है classification की. This section is a marks machine in ICA exams. Every category here has appeared as a question. So first we'll go to the first head number 1, based on incorporation. तो हम यहाँ brief में बात करेंगे. पहली आती है chartered companies. These are incorporated by Royal Charter. This is a British era concept and not relevant in India. This is for your awareness only. Second are statutory companies. These are incorporated by special act of parliament. For example, RBI, which is under RBI Act 1934. Then LIC, governed by LIC Act 1956. They're governed by their own acts. Third is registered companies. These are incorporated under the Companies Act. This is what we are studying. All Companies Act 2013 companies are registered companies. The next head is based on liability. First is limited by shares in section 2 subsection 22. So these are the companies limited to unpaid share amount, which is the most common type. Second is limited by guarantee, section 221. These are members guarantee a fixed sum at winding up. No shares used by clubs, chambers of commerce or non-profits. Third is unlimited, section 2 subsection 92. Here there is no limit on liability. Members' personal assets can be attached and these are extremely rare to see. Third head is based on number of members. This is the most important classification for the exam. So go through every type very carefully. Here first is one person company, also known as OPC. This is contained in section 2 subsection 62. So one person company means a company which has only one person as a member. Now before 2013, you needed at least 2 persons for a private company. One person could not form a company. The Companies Act 2013 changed this. अब एक अकेला entrepreneur अपनी कंपनी बना सकता है with limited liability protection. Concept क्या है अब इसके पीछे? That why did law create OPC? To encourage solo entrepreneurs, freelancers, consultants, small business owners to formalize their businesses without needing a partner just to meet a legal requirement. Now key features. Key features are only one member who must be a natural person. That is not a company or LLP. Should be an Indian citizen and resident in India, which means stayed in India for equals to more than 182 days in the immediately preceding calendar year. Second, a nominee must be named in the memorandum at incorporation. If the member dies or becomes incapacitated, nominee becomes the member. Third, nominee must also be a natural person, Indian citizen and resident in India. Fourth, OPC cannot be converted into a Section 8 company. Expressly prohibited है ये. Fifth, OPC cannot carry on non-banking financial investment activities. अब यहाँ पर एक critical exam update बता देती हूँ आपको. That earlier there was a mandatory conversion rule. If OPC's paid up capital exceeded rupees 50 lakhs or average annual turnover exceeded rupees 2 crores, it had to convert compulsorily. Now, this mandatory conversion requirement was removed by the Companies Incorporation 5th Amendment Rules of 2021. So, as of the recent syllabus, there is no mandatory conversion for OPC. Conversion is voluntary only. अब एक और confusion point आता है. Students ask, ma'am, if mandatory conversion is removed, can an OPC grow into a very large business without converting? The answer is yes. The law no longer forces you. After 2021, an OPC can legally remain an OPC regardless of its size. But here's the practical reality. If your business grows significantly and you want to bring in investors, raise capital, or go public eventually, you will want to convert to a law multiple members. The law removes the compulsion. Business sense still guides the decision. Next, we have private company, which is contained in section 2 subsection 68. Now, the statutory definition is that private company means a company having a minimum paid up share capital as may be prescribed and which by its articles restricts the right to transfer its shares, limits the number of its members to 200 and prohibits any invitation to the public to subscribe for any securities of the company. The three restrictions, which are the definition, and you have to understand why each restriction exists. So first is the transfer restriction. Why? because private companies are closely held. Existing shareholders know and trust each other. Unrestricted transfer would allow unwanted outsiders to enter without consent. The restriction preserves the private nature. Next is maximum 200 members. Why? Beyond 200 investors, a company starts resembling a public offering and should be regulated as such. But now note, employee members are excluded from this count. Current employees who are members and former employees who became members while employed and continue to hold shares are not included while this count is done. Third is no public invitation. Why? Because if you are inviting the public to invest, you need the disclosures, the regulations and investor protections that come with public companies. A private company bypasses those, so it cannot invite public investors. So remember, there will be minimum 2 members, maximum 200 members, and the name ends with private limited. तो एक ट्रिक बताती हूँ यहाँ पर आपको कि प्राइवेट कंपनी में 3 चीजें नहीं होती हैं. शेयर्स फ्रीली मत बेचो, 200 से ज्यादा मत लो और पब्लिक को इनवाइट मत करो. अब एक और कंफ्यूजन का पॉइंट ले लेते हैं. स्टूडेंट्स बोलते हैं, मैम, इफ प्राइवेट कंपनी क्रॉसेस 200 मेंबर्स, does it automatically become a public company? The answer is no. Crossing 200 members is a violation of the articles which define private company status. The company is in breach and will face penalties, but it does not automatically convert to a public company. Conversion to public company requires a deliberate formal process, which includes alteration of articles, filing with ROC, meeting the minimum 7-member requirement, and automatic conversion does not happen just by exceeding a threshold. Next we have is public company, which is contained in section 2, subsection 71. Now public company means a company which is not a private company. Yes, the definition is literally, it is not a private company. The Act defines it in negative. Why? Because the 3 restrictions of a private company are the defining features. If you absent those restrictions, you're public. So the negative definition works perfectly logically. Now एक critical proviso है, वो देख लेते हैं. That a subsidiary of a public company shall be treated as a public company, regardless of what its own memorandum and articles say. Why? Because Companies Act does not allow a public company to escape its obligations by channeling operations through a private subsidiary. The group must be treated consistently. अब यहाँ पे ICI का एक ट्रैप आता है, वो देखते हैं जल्दी से. So, for example, PQR Private Limited is a subsidiary of ABC Limited, which is a public company. Now, how many minimum directors must PQR have? The answer is 3. The public company rules apply and not 2. Students who don't know the proviso will answer 2 and will lose marks. So a quick revision, minimum 7 members, maximum is no limit, and the name ends with limited. And now we'll have a comparison of private versus public company. Minimum numbers की बात आती है तो private has 2 and public has 7. Then maximum numbers in private there are 200 and public there is no limit. Transfer of shares private में restricted, public में they are freely transferable. Then public invitation private के लिए prohibited and for public it is permitted. Then minimum directors in private there are 2 and public there are 3. नेम सफिक्स की बात आती है तो प्राइवेट के आगे लगेगा प्राइवेट लिमिटेड और पब्लिक के आगे लगेगा लिमिटेड. नाउ सब्सिडियरी ऑफ पब्लिक कंपनी, इवन इफ इट इज अ प्राइवेट कंपनी इट विल बी ट्रीटेड एज अ पब्लिक कंपनी. तो ये जो कंपैरिजन मारा है इसका रट्टा मार लो. इस पे बेस्ड जो क्वेश्चंस बताएंगे हर 2-3 अटेम्प्ट्स में आते ही हैं. नाउ विल गो टू स्पेशल टाइप्स ऑफ कंपनीज. फर्स्ट विल गो टू स्मॉल कंपनी व्हिच इज explained in section 2 subsection 85. Now a small company means a company which is other than a public company and whose paid up share capital does not exceed rupees 4 crores and turnover as per its last profit and loss account does not exceed rupees 40 crores. Now, these both conditions are simultaneous in nature. Why? Because compliance burden must be proportionate to size. A company with rupees 2 crore capital and 8 employees does not need the same governance infrastructure as a company with rupees 500 crore capital. Small companies get relaxations, only 2 board meetings per year and simplified annual return. Now, who is excluded even if conditions are met? First, holding company. Second, subsidiary company. Number 3, the Section 8 companies. And number 4, the companies governed by special acts. तो अब यहाँ पे एक ICI का ट्रैप देख लेते हैं कि स्टूडेंट्स लिखते हैं if paid up capital is less than or equal to 4 crore or turnover is less than or equal to 40 crore, it's a small company. Wrong. It's and not or. Both conditions must be satisfied. If either is exceeded, it is not a small company. एक ट्रिक है यहाँ पर कि 4 और 40 दोनों साथ तब बनती है स्मॉल कंपनी. Next we'll see government company. This is contained in section 2, subsection 45. A government company means any company in which not less than 51% of the paid up share capital is held by the central government or any state government or governments or partly by both. A subsidiary of a government company is also a government company. Now, why is this into effect? Because the state control means public accountability obligations. The definition follows the money. Wherever 51% plus government money is, government company obligations follow. For example, ONGC, BHEL, NTPC, Coal India, etc. Next, we have foreign company, which is explained in section 2, subsection 42. Now, foreign company means any company or body incorporated outside India which has a place of business in India, physically or through electronic mode, and conducts any business activity in India. Why? Because companies operating in India must comply with Indian law, regardless of where they were incorporated. The definition captures companies that use India as a market while avoiding Indian incorporation. For example, Ample Inc., Google LLC, Amazon.com Inc., all foreign companies under Indian law. Next, we'll see the definition of dormant company, which is there in section 455. It can apply to ROC for dormant status when formed for a future project or has no significant accounting transaction. It must have minimum 3 directors. So, इसकी एक ट्रिक है, वो क्या है कि सोई हुई कंपनी है, फ्यूचर के लिए रखी है, कोई काम नहीं करती अभी, इसलिए वो एक dormant company है. Next, we have a section 8 company. These are formed for promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, environment, and applies profits only to those objects and no dividend is given. So why they were made? Non-profit organizations need a stable legal structure. The company form gives them legal personality, perpetual succession and governance structure, while the no dividend rule ensures the charitable purpose is maintained. For example, CII, various trade chambers, education institutions. Next, we move to section 6, which has holding, subsidiary and associate companies. We'll study the 3 critical relationships. So these 3 definitions appear in ICI exams with remarkable frequency. We'll learn each of them with precision. First, we have this subsidiary company. I'll apologize in advance. Earlier I said section 6. It necessarily does not mean the section. It means the part 6. Okay, so please do not confuse. So now coming back to the topic, we move ahead with subsidiary company, which is explained in section 2, subsection 87. So by definition, it means a company shall be deemed to be a subsidiary or another company, which is the holding company, if first, the holding company controls the composition of its board of directors, or second, the holding company holds, either by itself or together with its own subsidiaries, more than half in nominal value of the equity share capital of the other company. Or, third condition is, the other company is a subsidiary of a company which is itself a subsidiary of the holding company. सो इन तीन कंडीशंस में से कोई भी एक सेटिस्फाई हो जाती है तो वो कंपनी सब्सिडरी कहलाती है. Now we'll study each of these conditions in detail. So condition first is board composition control. Now holding company can appoint or remove the majority of directors of the other company. Why is this done? Because board of control is the real control. Even with minority shareholding, controlling who sits on the board gives effective governance authority. Okay, so coming to the next condition, which says more than 50% equity. So here, holding company directly or combined with its own subsidiaries holds more than 50% equity shareholder, equity share capital. तो यहाँ पे ICI का एक ट्रैप आ जाता है कि the text says more than half, not 50% of more. Exactly 50% does not satisfy this condition. यहाँ पे examiner exploits this precision regularly कि ध्यान रखिएगा यहाँ पर कि more than half है. It is not 50% of more. तो अगर 50% आ गया तो गलती मत करके आ जाइएगा. We'll move ahead with the third condition, which is subsidiary of a subsidiary. Now, for example, if XYZ is a subsidiary of ABC, and on the other hand, LMN is a subsidiary of XYZ, then LMN is also a subsidiary of ABC. यहाँ पर एक ट्रिक देख लेते हैं छोटी सी कि सब्सिडियरी की सब्सिडियरी भी सब्सिडियरी होती है. पूरे चेन में होल्डिंग का अथॉरिटी चलता है. So keep this in mind accordingly. Next, we'll move ahead with holding company, which is explained in section 2, subsection 46. By definition, it says, a company shall be deemed to be the holding company of another if that other company is its subsidiary. Now, these are mirror definitions. One controls is the holding company, one who is controlled is the subsidiary. Okay? आगे चलते हैं, बात करते हैं एसोसिएट कंपनी की, which is explained in section 2, subsection 6. So by definition, it states that associated company means a company in which another company has a significant influence, but which is not a subsidiary of that company. So significant influence का मतलब क्या होता है कि at least 20% of total voting power हो या फिर और control or participation in business decisions under an agreement. Remember the two conditions which signify the significant influence. First is associate should have more than or equals to 20% voting power, but it should not be subsidiary. Okay. So we'll study the ownership spectrum. So अगर ownership level 20% voting से कम होगा तो कोई स्पेशल स्टैट्यूटरी रिलेशनशिप नहीं है. अगर ओनरशिप जो है लेवल वो मोर देन और इक्वल टू 20% है बट इट इज नॉट सब्सिडरी तो कहलाएगी एसोसिएट कंपनी. वहीं पर अगर बोर्ड ऑफ कंट्रोल हो या फिर 50% से ज्यादा इक्विटी हो तो कहलाएगी सब्सिडियरी कंपनी. ओके. नाउ व्हाई दिस डिस्टिंक्शन मैटर? Associates are accounted for under the equity method in consolidated financial statements. Subsidiaries are fully consolidated. The legal and financial treatment differs significantly. We'll study a trick कि 20 से 50 के बीच है तो एसोसिएट है, 50 क्रॉस करो या बोर्ड कंट्रोल ले लो तो सब्सिडियरी है. ये लाइन याद रखनी है. We'll take up a case of a confusion which is frequently met with by students. So students often ask, ma'am, what if a company holds exactly 50% equity? Is it a subsidiary? No, not under the second condition that we just did. The requirement is more than half, exactly 50% falls short. पर यहाँ पर एक examiner का trap है within the trap. Check condition 1 as well. If along with 50% equity, the company also controls the board composition, it is a subsidiary under condition 1. Okay, never check just one condition, all three must be evaluated. So 50% equity alone plus no board of control is associate because it has significant influence, but it isn't a subsidiary. Now 50% equity plus board of control becomes subsidiary under condition 1. Okay. Now we'll take the एग्जामिनेशन इंजन चैप्टर 1 पार्ट 1. अब हम करते हैं वो सेक्शन जो तुम्हें एग्जाम में एक्चुअली मार्क्स दिलाएगा, सो ध्यान से देखना है. We'll take into consideration the 5 ICI traps out of this lecture 1 topic. Okay, so these are the specific points where the examiner catches unprepared students. So you have to carefully know each one. Trap number 1 क्या है? Common seal. So the mistake is a company must have a common seal, whereas the correct answer is common seal is optional since the Companies Amendment Act 2015. Where this appears? In definition questions, characteristic questions, MCQs. So here you have one line to remember that under the Companies Act 2013 as amended, having a common seal is optional for a company. Next is trap 2, which is the OPC mandatory conversion. The mistake that students do is that if an OPC's paid up capital exceed rupees 50 lakhs or turnover exceeds rupees 2 crores, it must compulsorily convert. Whereas the correct answer is this requirement was deleted by the Companies Incorporation 5th Amendment Rules 2021. So now no mandatory conversion exists anymore. ये कहाँ पे आता है? OPC questions में, application based questions on conversion में. यहाँ पर आपको क्या ध्यान रखना है? That after the 2021 amendment, an OPC can only voluntarily convert and there is no mandatory conversion requirement. अब हम देखते हैं ट्रैप नंबर 3, जिसमें है कि subsidiary of public company is treated as public company. So mistake students do is they assume that PQR Limited is a private company just because it has private in its name. Whereas the correct answer is PQR is a subsidiary of a public company. It is treated as a public company under the proviso to section 2 subsection 71. Private company privileges do not apply. ये हमें कहाँ पूछा जाता है? एप्लीकेशन क्वेश्चंस अबाउट मिनिमम डायरेक्टर्स में आ सकता है, फिर पब्लिक इन्विटेशन में, कंप्लायंस रिक्वायरमेंट्स में. सो यहाँ पर आपको क्या ध्यान रखना है? That before answering any question about a private limited company, you have to first check if it is a subsidiary of a public company. Okay? Next trap आता है more than half versus 50% or more. So mistake the students make here is that if a company holds 50% equity of another company, the second company is its subsidiary. Whereas the correct answer is that as per section 2 subsection 87 part 2, it requires more than half a nominal value of equity share capital. Exactly 50% is not enough under this condition. अभी हमसे कहाँ पूछा जाता है? MCQs में, एप्लीकेशन क्वेश्चंस ऑन सब्सिडियरी रिलेशनशिप्स में, यहाँ पर. तो हमें यहाँ पे क्या ध्यान रखना है? That if equity is exactly 50% and it is not subsidiary under part 2, then you have to check condition 1. That is board composition controlled. If yes, then it is a subsidiary under part 1. Okay, under condition 1. Now we'll take trap number 5. Sorry. Which is small company में and है, not or. Okay, the mistake students make here is that, for example, a company with paid up capital of rupees 2 crore qualifies as small company even if its turnover is rupees 60 crores. The correct answer is that both these conditions must be satisfied simultaneously. Capital should be less than equal to 4 crore and turnover should be less than or equal to 40 crore. Exceeding either condition disqualifies the company. Okay, remember that. Now, where this is asked? In application questions, MCQs on company classification. So now you have to remember to check both the numbers. If either is out of range, it is not a small company. तो अब हम थोड़े से MCQs जो हैं वो डिस्कस कर लेते हैं. So we'll take first MCQ. Which of the following is not a characteristic of a company under the Companies Act 2013? First option A is perpetual succession. Option B, limited liability of members. Option C, mandatory maintenance of a common seal. And option D, transferability of shares. So the correct answer is option C, because common seal is optional and not mandatory. Rest all the three conditions are all genuine characteristics. Next MCQ is ABC Limited, which is a public company, holds exactly 50% equity in XYZ Limited. Now, ABC Limited also controls the composition of XYZ Limited's board of directors. Here, XYZ Limited is, your option A is an associate company of ABC Limited. B, a subsidiary of ABC Limited under condition 2 of section 2, subsection 87. Option C, a subsidiary of ABC Limited under condition 1 of section 2, subsection 87. और option D, neither subsidiary nor associate of ABC Limited. अब आप इसको प्लीज आंसर कीजिए बिफोर आई गिव माई आंसर. I hope you must have done that. So now we'll go to the correct answer. It is option C. 50% of equity does not satisfy condition 2, which requires a more than half. However, board composition control satisfies condition 1. So therefore, XYZ is a subsidiary under condition 1 and not 2. This is the double trap MCQ testing, both the 50% precision and which condition applies. Next, we'll see third MCQ. Which of the following companies cannot be classified as a small company under section 2, subsection 85? Option A is a manufacturing company with paid up capital of rupees 3 crores and turnover of rupees 32 crores. Option B, a service company, paid up capital of rupees 1 crore and turnover of rupees 15 crores. Option C, a holding company with paid up capital of rupees 2 crores and turnover of rupees 18 crores. Or option D, an IT company with paid up capital of rupees 3.5 crore and turnover of rupees 28 crores. So correct answer here is option C. The holding companies are expressly excluded from small company definition, regardless of capital or turnover figures. Therefore, option A, B, and D all satisfy both the capital and turnover conditions and are not excluded categories. Next, we'll see MCQ number 4. So the question is, central government holds 40% and a state government holds 15% of paid up share capital of WFG Limited. WFG Limited is, your options are option A, not a government company, because central government alone holds less than 51%. Option B, a government company. Option C, a private company. और option D, a section 8 company. यहाँ पर जो करेक्ट आंसर है वो है ऑप्शन बी, क्योंकि सेक्शन 2 सबसेक्शन 45 includes companies where capital is held partly by central government and partly by one or more state governments. So यहाँ पर 40% plus 15% हो जाता है 55%, which is more than 51%. So therefore, WFG Limited is a government company. यहाँ पर examiner traps students who thinks only central government share counts. Okay. Next, we'll see MCQ number 5. The question is, the doctrine of separate legal entity in company law was firmly established by option A, Daimler Company Limited versus Continental Tire and Rubber Company Limited. Option B, Hayden's case of 1584. Option C, of Salomon versus Salomon and Company Limited of 1897. And option D, Gray v. Pearson of 1857. Your correct answer is option C. Salomon versus Salomon established that a company is a person distinct from its shareholder. Option A established enemy character. Option B established the mischief rule. And option D established the golden rule. So with this, we move towards the descriptive questions, the sample questions out of lecture 1. So these are fully exam pattern questions, and please practice writing the complete answers. We'll take into consideration the first descriptive question, question number 1, and this is for 5 marks. So the question is, explain the concept of separate legal entity as established in the case of Salomon versus Salomon and Company Limited of 1897. State any 3 characteristics of a company that flow directly from this concept. तो मैं आपको एक मॉडल आंसर का डायरेक्शन दे देती हूँ. So you have to, and again I'm emphasizing this again and again, please practice questions. आप लेक्चर सुनेंगे पूरा का पूरा, आप एमसीक्यूज पढ़ेंगे तो उससे आपको कंसेप्ट क्लियर हो जाएंगे. जब आप साथ के साथ उसकी आंसर राइटिंग भी कर लेंगे तो आपको एग्जामिनेशन में एक एज मिलेगा. इट इज अ कॉम्पिटिशन, सो इट विल बी वेरी वेरी हेल्पफुल टू यू. प्लीज डू नॉट फेल. ये ऐसा नहीं आपने सिर्फ लेक्चर सुन लिया, शॉर्ट में बन गया, ठीक है रिविजन हो रही है, नहीं. यू हैव टू प्रैक्टिस क्वेश्चंस आल्सो. दे रीइंफोर्स द कॉन्सेप्ट्स दैट यू हैव लर्नड. Okay, so now we'll move back to our what we are doing. So we'll answer the model answer. So इसमें पैरा 1 में आप क्या करेंगे, आप डेफिनेशन लिखेंगे that company is a legal person distinct from its member. You have to cite section 2 subsection 20 as a statutory definition. Para 2 will be the Salomon case. State the court, that is House of Lords 1897. Briefly describe the facts that Solomon, it was wood manufacturer, converted to company, then company went insolvent. Then state the holding that company is a different person altogether from the subscribers. Okay. Then para 3 में आ जाएगा 3 characteristics that flow from separate legal entity. First would be company can own property in its own name, flows from being a separate person. Then second हो जाएगा perpetual succession. It flows from independence from members' lives. And third हो जाएगी company can sue and be sued independently. This flows from legal personality. यहाँ पर एक चीज ध्यान रखना कि limited liability is a consequence of separate legal entity and not a characteristic that uniquely flows from it. But if you cite it, explain the logical connection, that is acceptable. Next, we'll take the question number 2. This is for 6 marks. The question is, classify companies on the basis of the number of members. Distinguish between a private company and a public company under the Companies Act 2013. अब हम यहाँ पे मॉडल आंसर जो है एक देख लेते हैं क्या डायरेक्शन रहेगा. इसमें हम पार्ट्स में इसको डिवाइड करेंगे 2 पार्ट में. फर्स्ट पार्ट में हम बात करेंगे क्लासिफिकेशन बाय मेंबर्स की. सो ओपीसी जो है वो 1 मेंबर की होती है. दिस इज डिफाइंड इन सेक्शन 2 सबसेक्शन 62. यू मेंशन द डेफिनेशन हियर. देन प्राइवेट कंपनी में 2 से 200 के मेंबर्स होते हैं. दिस इज डिफाइंड इन सेक्शन 2 सबसेक्शन 68 एंड ऑल्सो मेंशन द 3 restrictions. Then public company, it has minimum 7 and there is no limit of maximum members. So this is defined in section 2 subsection 71. Okay. Next we come to part 2. यहाँ पे you have to distinguish. Use tabular format जो 7 points का table है. So उसमें क्या होगा 6 marks की आपकी coverage comfortably आ जाएगी. यहाँ पे आप क्या क्या include करेंगे उन pointers में कि minimum members, then maximum members, then transfer of shares, then public invitation, मिनिमम डायरेक्टर्स कितने होंगे, नेम का सफिक्स क्या रहेगा, देन सब्सिडियरी ऑफ पब्लिक कंपनी रूल. ओके, विद दिस यू विल हैव अ गुड ड्राफ्टेड आंसर. We'll take up the third question. The third question again is for 5 marks. It states that what is meant by lifting of corporate veil. Explain any 3 statutory circumstances under which the corporate veil may be lifted under the Companies Act 2013. सो अभी यहाँ पे आपको मैं मॉडल आंसर है उसका एक डायरेक्शन बता देती हूँ, जस्ट एन आउटलाइन सो दैट यू कैन राइट इट वेल. प्लीज डू राइट, अगेन आई एम एम्फसाइजिंग इट. सो यहाँ पर आप इसका फर्स्ट पैरा जो होगा उसमें आप कॉन्सेप्ट बताएंगे कि द कॉर्पोरेट वेल इज द लीगल सेपरेशन बिटवीन अ कंपनी एंड इट्स मेंबर्स. यू हैव टू साइट द सलोमन केस. देन लिफ्टिंग मीन्स कोर्ट्स या जो एक्ट है, इट लुक्स थ्रू दिस सेपरेशन एंड होल्ड्स एक्चुअल पर्सन्स लायबल. Then you'll explain into detail the 3 statutory circumstances. First one being the reduction of membership below minimum, which is stated in section 3A. Define, state the 6-month period, state consequence, that personal liability for debts incurred after 6 months. Explain that in detail. Then next is fraudulent trading. So here define, state intent to defraud creditors, then state consequence wherein personal liability is taken without in the limit. Third would be the misrepresentation in prospectus, where directors personally are liable for investor losses from untrue statements. Okay. So now, अभी आपको अब हम आगे पार्ट करते हैं जहां मैं आपको एग्जाम में लिखने के लिए थोड़ी सी गाइडेंस दे रही हूँ. ठीक है. रिमेंबर, बीइंग राइट इज नॉट इनफ इन सी एग्जाम. यू ऑल्सो हैव टू राइट इन अ वे द एग्जामिनर कैन क्विकली क्रेडिट. ठीक है. ये सिंपल रूल्स है, इनको फॉलो करेंगे आप. Rule number 1 है always cite the section number. So when you define anything from the Companies Act, you start with under section XYZ of the Companies Act 2013. ये ऐसा इसलिए क्योंकि आईसीए का जो एग्जामिनर है उसकी मार्किंग स्कीम जो है वो ऑफन एक्सप्लिसिटली एलोकेट्स 1 मार्क जस्ट फॉर साइटिंग द करेक्ट सेक्शन. सो राइटिंग द डेफिनेशन विदाउट द सेक्शन नंबर लूजेस दैट मार्क फॉर फ्री. मतलब जितना हो सकता है. ऑल्सो यहाँ पर मैं एक चीज इमीडिएटली आपको बता दूं कि अगर आपको कंफ्यूजन है ना सेक्शन नंबर में, प्लीज प्लीज डू नॉट राइट इनकरेक्ट सेक्शन. अगर आपको नहीं है तो अंडर द प्रोविजंस ऑफ कंपनीज एक्ट रख दीजिए, बट डू नॉट राइट एनी इनकरेक्ट सेक्शन. जितना हो सके हम कोशिश करेंगे हम करेक्ट सेक्शंस को याद करने की, बट अगर सेक्शन गलत हो जाता है तो गलत आंसर, गलत सेक्शन कोट नहीं करना है, वो आपको पूरा आंसर गलत हो जाएगा. प्लीज रिमेंबर दैट. Rule number 2 is for distinguished questions, always use a table. So never write distinctions in paragraph form. A 5-point table clearly presents 5 comparison points. The examiner here can verify each point in seconds and assign marks. Paragraph form varies your points. So minimum 5 points for a 5-mark distinguished question, minimum 7 points for a 6 to 8 mark question. Simple. 1 point for each mark. That way. Third rule is for application questions, use the 3-step structure. Now every application question should be answered with step number 1 क्या होगा? State the law that under section XYZ of Companies Act 2003, then state the rule that applies. Okay. Step 2 क्या हो जाएगा? That apply this to the facts that in the given case, and then you refer to specific facts from the question. Then we'll go to step 3. It will be your conclusion para. You'll say therefore, and then you do conclude your answer. So never give a conclusion without stating which law you're applying. Never state the law without connecting it to the facts. These 3 steps always. Okay. Next, we'll go to rule number 4. For case law questions, cite quote, year, and 1-line holding. Okay. Now, you do not need to produce or reproduce the full judgment. Right? In the case of this name, year, and which court said that it was, and then you write it was held that, then you simple write the 1-line principle. That is sufficient and earns full marks for the case citation. Now here students lose marks not because they don't know the case, but because they give 5 lines of story and forget to state the actual holding. हमने round नहीं खेला. You don't have to beat around the bush. Just be very specific and then you move ahead with your answer with respect to the question being asked. Next we'll go with rule 5, which is the common mistake that costs the marks. So mistake number 1 यहाँ पे क्या है? That writing common seal is mandatory. It is optional after 2015 amendment. Mistake number 2 क्या है? Writing the old OPC mandatory conversion rule. It was removed in 2021. Mistake 3 क्या है? Forgetting the subsidiary of public company, which is treated as public company proviso. Then mistake 4 है writing 50% equity is equal to subsidiary. It is more than 50%. Mistake 5 क्या हो जाती है? Writing either condition for small company. It is both conditions. So these 5 mistakes alone cost students 3 to 5 marks per paper. So now you know and do not repeat these mistakes. So this completes our lecture 1. Now here we have covered the why behind separate legal entity, Solomon's case, all 6 characteristics, lifting of the corporate veil, complete classification of companies, holding or subsidiary or associate relationships, and the examination engine. So before we proceed to lecture 2, I have a small homework for everyone. And please do this homework. So first is write the 3 restrictions of a private company from memory and without notes. Second is write all 3 conditions that make a company a subsidiary from memory only. And third is your attempt all 3 descriptive questions on paper. Use the 3-step structure for application questions. So next we'll go to lecture 2 in the next video. Lecture 2 will cover your all the critical definitions, that is KMP, managing director, whole-time director, manager, officer in default, financial year, free reserves, net worth, turnover, plus the chapter 1 complete drill. ये definitions direct marks है. Lecture 2 बिल्कुल भी मत छोड़ना. Stay consistent, 1 lecture a day. This paper rewards the students who doesn't skip. So having said that, we'll see you in lecture 2 only on Brainacular Academy. If you like the video, please share, like, share, comment, and subscribe. And also follow us on Telegram app. And I'll see you in the next video. Bye.